Good afternoon, everyone. Welcome to the EP Room. I know many of you know me, but some don't. So if you don't know me, my name is Ian Wilson. I am an assistant professor of religious studies here and also director of the Chester Ronning Center, and I'd like to welcome you all. We do have some snacks, as you all know, and it seems like there's some left, so feel free to grab more, especially in between speakers, or if there's a brief break, feel free to grab some more if you're thirsty or still a little hungry. So I'm here to introduce a special pair of lectures that we are hosting this afternoon. One to be given by Professor Rebecca Probert of the University of Exeter, who is currently a University of Alberta Distinguished Visiting Scholar. And another lecture to be given by our very own Dr. Katharine Batlan, postdoctoral fellow at the Chester Ronning Center. Although the Ronning Center is officially hosting today's lectures, I would like to give a special recognition to Dr. Melanie Mitho, who's Associate Professor of History here at Augustana, and who really made this event happen. Dr. Mitho is a historian of marriage in Canada, as many of you know. And although she doesn't focus on marriage and religion per se, it is safe to say that the topic of religion is never far away in any discussion of marriage in our context. I can think of few other hot-button topics in popular discourse right now than marriage law and its relation to religion, religious beliefs, religious practices, and communities. So when Melanie approached me about helping to support a University of Alberta distinguished visitor who is an internationally renowned expert in marriage law, I said, yeah, sure. I think that could work. And here we are. So thank you, Melanie, for letting us join in with your distinguished visitor, who will be here for a while. She gave a lecture last night, of course, in your cameras, but is also lecturing at North Campus and also at the University of Calgary, and I think will be headed to the mountains. So is here for a proper stay in Alberta. So now for the proper introduction. So our first speaker is Rebecca Probert, who is Professor of Law at the University of Exeter. Professor Probert has lectured and published extensively on the legal, social, and cultural foundations of marriage in the United Kingdom, in Europe, more broadly in the modern era. It's a cliche in academic introductions like this to say things like, oh, so-and-so's publications are too long to list, or whatever, some variation on that. In this case, I honestly cannot list them all, or even come close to it. Her CV is truly extensive. For example, by my count, she has authored or edited some 31 books. Okay, not articles or short pieces, books, okay? And on top of articles and other short pieces. These titles include, for example, Marriage Law in Practice in the Long 18th Century, a Reassessment, and The Changing Legal Regulation of Cohabitation, From Fornicators to Family, from 1600 to 2010. Both of these published by Cambridge University Press. If you have questions about marriage and the history of marriage in the UK, this is literally the person to ask. Today, Professor Probert will speak to us about British family law myths and some of the historical underpinnings of those myths. Our second speaker is a scholar whose career is just beginning, but whose work will undoubtedly, in the years to come, have just as much of an impact as Professor Probert's. Dr. Katharine Batlan is the postdoctoral fellow of the International Fellows here at the Ronning Center. Her research expertise is the history of law in North America as it relates to religion and religious communities. Her first book, which is in preparation, looks at attempts to amend the U.S. Constitution to include references to Jesus, and also looks at how different religious communities responded to such attempts. In a quick plug, she'll be talking about that specific research at an Augustana Lunch and Learn on February 7th. So please mark your calendars and look forward to that. Katharine is also currently organizing an international conference on religion and law in North America that will take place here at Augustana in April. And today she'll be speaking to us about religious responses to recent marriage law changes in the American context. So how this will work is Professor Probert will go first, and she will share her lecture, and then there will be some time to interact with her, ask questions of her. And then we will transition to Dr. Batlan's talk, have some time to ask her questions, and then there'll be time at the end for general discussion and additional questions if there are any. So thank you all. Let's welcome both of our guests. I'll hand it over to Professor Probert.
Well, thank you very much, Ian, for that wonderful introduction. Renewed thanks to Melanie for organising all of this and bringing me here, and to all of you for attending today. It's a real pleasure to have such a great audience to speak to. So my topic today is quite a specific one at one level. It's looking at the evolution of a particular myth about the way in which English law has interacted with marriage and cohabitation. But it does allow me to talk about over 250 years of legal and social development, to draw on a range of different sources and methodologies, and to really think about the sort of broad sweep of how the law has regulated marriage and cohabitation. And although I'm not going to be looking at religious definitions of marriage specifically, I am very much going to be looking at the religious roots of marriage regulation, because in the beginning of my period, marriage was still regulated by the church. And one of the reasons why the myth has taken such a hold and has proved so difficult to shift is, I think, an ignorance of the way in which the church and religion did interact with marriage in this early period. So, in England, there is a widespread belief among modern cohabiting couples that they have the same rights as if they were married. Recent surveys put the proportion at least 55–60% of couples holding this belief. And this is clearly problematic in a system that doesn't give cohabitants the same rights as if they were married, because couples may make arrangements in the belief that they will be protected, they may make themselves vulnerable by giving up jobs, by undertaking caring relationships, and then at the end of the relationship find that they're left with nothing. So it's clear that we do not at present have a concept of common law marriage. But a number of scholars have claimed that we used to have, and that one reason why modern cohabitants believe that they're protected is that common law marriage did once exist. So the claim that has been made is that before 1753 it was possible to have a common law marriage. Now, definitions of this are often quite loose in these claims. So some people are saying that a common law marriage was simply an exchange of consents, that created a marriage. And some people are saying that simply by living together, a couple would be presumed to be married. And I'll be looking at both of those ideas and showing that actually neither of those meanings hold good. We did not have common law marriage in 1753 or before 1753 any more than we have it today. And I do think that it is a bit of a stretch to say that modern cohabitants must believe in this because it existed 250 years ago. I mean, that would be a very tenacious folk memory. As I will show, there are much better reasons why modern cohabitants believe in common law marriage, and it's a myth of a much more recent inception. So I'm going to unpack different aspects of the claim. So, first of all, did the term common law marriage actually exist before 1753? Well, no, because there was simply no reason to. Before 1753, marriage was governed by the canon law. It's governed by the law of the church. In one sense, you could say this was a common law of marriage that existed across Christendom. But that terminology wasn't really used. And this is where the sort of resources that are available to modern historians are particularly useful, because we can search so many more sources now digitally for use of particular terms. We can be much more confident in saying we found no evidence of this term in these hundreds of thousands of books and journals, so perhaps our starting assumption should be that it probably didn't exist in this period. So the sources that I've looked at for this have been databases such as 18th century collections online, which is full text, fully searchable, of over 100,000 books that were published in the 18th century. Now, it may be objected that if this is some informal method of marrying, perhaps it didn't leave any trace in the formal records. Nobody who was literate wrote this down. But there are lots of sources that capture the words and speech of people from all walks of life. So the Old Bailey, which is the central criminal court in London, the students are going to be looking at later in the module, records the speech of witnesses. So that's a fantastic resource, and there is no mention of any of them mentioning common law marriage either. Similarly, when one looks at diaries, again, lots of these have now been digitised and searchable, not a mention. So I feel relatively confident in saying that the term simply did not exist. You would have talked about the canon law of marriage, not the common law. But did the concept exist? So we've got these two different aspects. First of all, the exchange of vows. Now, a simple exchange of vows in this period was binding on the parties. So if you had said that you were agreeing to marry somebody, then there were remedies available to that person if you subsequently changed your mind. But it didn't create a marriage, and this is a really crucial distinction between what's binding and what's a valid marriage. This is illustrated by a number of facts. First of all, parties didn't have the same rights as if they were married. So if a couple had exchanged vows and then one of them died, the survivor wasn't entitled to inherit the other's assets as if they had been married. They were not meant to engage in any kind of sexual relationship after a simple exchange of vows. They still risked being punished for fornication by the church courts if they did so. And going through a second ceremony of marriage with somebody else did not constitute the crime of bigamy. So again, this is a way we can test whether something is or is not a marriage. What's the consequences of going through a further ceremony of marriage? Again, if we look at the Old Bailey from the early 18th century, nobody claimed that the crime of bigamy had been created by going through a ceremony of marriage after this informal exchange of vows. And thirdly, if the existence of this exchange was challenged, so you can imagine the scenario, it's a romantic occasion, somebody has said that they're in love with the other, they've exchanged these vows, and then one of them's changed their mind. What happens then? Well, if it goes to court, if they can prove that this exchange of vows has actually taken place, the court doesn't say, great, we recognise you as married, they will order the couple to solemnise their marriage in church. So this is underlining that this is binding, but it's not a marriage by itself. So all this is telling us that that simple exchange of vows didn't actually create a marriage. We didn't have common law marriage in that sense. The second way in which the term has been used has been to suggest that if you were living together, you were presumed to be married. Now, there is a grain of truth here, because all the best myths have a grain of truth in them somewhere. In a system before you had formal registration of marriages, before you had centralised registration of marriages, it could be quite difficult to prove that a particular couple had got married. Imagine that an inheritance hinges on whether your grandparents were married. You're going to court. If I asked you here and now, when and where did your grandparents get married? Would you be able to tell me instantly? Possibly not. You'd probably be able to go and get some documentary evidence of it. But when all of that evidence is recorded at parish level, where do you even start? So there was a useful working presumption that if the couple whose marriage was in question had lived together, had been reputed to be married, no one had ever challenged the marriage, the presumption was that they were married. And it was up to the people wanted to show that there wasn't a marriage to provide evidence that they hadn't actually got married. So, yes, we did have couples being presumed to be married, but only in these very particular circumstances. So if we look at how known cohabitants were treated by the law, we see something very different. So I've mentioned the ecclesiastical courts punishing couples for fornication. So if a couple were known to be living together outside marriage, this is what happened to them in the early 18th century. They might be required to do penance, clad in a white sheet before the congregation. This chap here has committed adultery, as you can see from the banner that is on his sheet, but the same applied to fornication as well. Now, most courts didn't actually differentiate between different types of fornication, but the Carlisle courts in the early 18th century very helpfully separated out this further category of living together unlawfully. And it's not even perceptible in the first column. You can see a tiny smudge of blue at the bottom of the second and third columns, handful of cases in the 1730s and 1740s. But it's a very small subsection of those punished for fornication as a whole. And this, I think, is probably telling us that there's not many cases of overt cohabitation, rather than that the community is tolerating overt cohabitation. Because if you have all these punishments for fornication, which from the records was generally quite surreptitious, why would the community tolerate couples openly living together outside marriage? And this is reinforced by the fact that in this period we have very little evidence of either cohabitation or informal marriage. So not only do we have a sort of recognised legal concept conferring rights of inheritance, we really don't have a significant population couples at all. And this is reinforced by the fact that it's possible to trace marriages for the vast majority of couples living together. And if you think about all the challenges of tracing marriages, if any of you have researched your family tree, the fact that you can trace them for 95% for a cohort is suggesting that you've probably got 100% of that cohort who are married and just a few that you can't find for one reason or another. So, common law marriage, I would suggest, never existed in England and Wales. So how did this myth emerge? Well, it seems to be a New York case from 1809, and I'm going to blame the Americans for this one, that makes the fundamental error of confusing binding and valid. So I've put up what the case said in Fenton and Reed in 1809, claiming that under English law you needed no formal solemnisation of marriage, a contract of marriage made in words of the present tense amounts to an actual marriage and is as valid as if made in the face of the church. The case it cites says almost that, but it's the difference between it being a marriage in the sight of God and a valid marriage. Early 18th century commentators knew that when you said a marriage was a marriage in the sight of God, it was not necessarily a legal marriage. It would be morally binding, but that's not the same as being legally valid. So this merger of terms occurred. This seems to have been the foundation in the States of their concept of common law marriage. But interestingly, 2 years later in England, we have the same claim being made about English law in the past. So I do not know if Sir William Scott, depicted here, had read Fenton and Reed, but it does seem a coincidence that 2 years after that decision, he should have come out with something quite similar and something which departs from his own earlier judgments. So Dalrymple and Dalrymple is a really key case in the history of English marriage law, because that's the case in which it's held that it had been possible to get married by a simple exchange of consent before 1753 in England. Now, the reason why Dalrymple is such a weak authority for that particular point, apart from the fact that it's being decided over 60 years after the period it's talking about, is that Dalrymple is actually a case about Scottish law. And all of the evidence is about Scottish law. All of the authorities are about Scottish law. And then there's a few lines going, and of course this was the same in England too. So, huge projection of the law of one jurisdiction into a different jurisdiction. English and Scottish law are very different. They cannot be assumed to be the same. So, we can see from cases decided before and after Dalrymple what a profound effect it has on understandings of marriage law. Cases decided before express uncertainty about the law was. They're certainly not attaching significant weight to that exchange of consent. Cases decided after Dalrymple say, okay, we only need to look at Dalrymple now. This has cleared the matter of all the uncertainty that might previously have attached to it. So it's seized upon as a clarification of the law. Although there are a few dissenting voices who say, hang on a minute, this really doesn't fit with our understanding of the law. it has a profound impact on how the law is applied across the developing British Empire. So there's quite a complicated development here, and I'm not going to explore it in full, but there is an assumption that English settlers, at least in some regions, take the common law with them. And the common law that they are taking with them is now the law of marriage as expressed in Dalrymple. That all you need for marriage is that simple exchange of consent. And as I said, it also, Fenton and Reed, leads to the emergence of the American concept of common law marriage. We also see the terminology starting to change. So, in the mid-19th century, commentators start to talk about the common law of marriage, the law that existed before statutory intervention in the mid-18th century. And the abbreviated term common law marriage seems to have emerged in US textbooks a little later. The first reference appears in an 1872 text on the conflict of laws, and is really only popularised in the 1890s in the States. And again, the fact that textbooks are now digitally searchable makes this kind of research so much easier, because you can look through all the different editions and you can see, well, they weren't citing it in the 6th edition, but suddenly in the 7th edition, they're talking about common law marriage. They're suddenly using this concept. And often it's prefaced with phrases such as so-called common law marriage, or what is now called a common law marriage, underlining the fact that this is a novel term. So we get the terminology emerging at the end of the 19th century. As I said, this is primarily in US textbooks. In the 20th century, it starts to creep into English textbooks, sometimes referring to US common law marriage, and sometimes referring to that possibility of getting married by a simple exchange of consent in far-flung parts of the empire where there hasn't been any specific regulation of marriage. It's only really popularised, however, in the 1960s. And there's particular debates in Parliament over recent immigrants to the country, and they are referred to as having common law marriages. And from this point, we can start to see a growing number of references to the term in the media. So, 1960s, there's an important shift away from using common law marriage to refer to a type of marriage, either US or overseas, and applying it to cohabitants. But this is very unlikely to be the source of the common law marriage myth, because the early references are overwhelmingly negative. If you are a common law wife in the newspapers in the 1960s, you are probably living with a criminal. The newspapers, almost exclusively use it in that context. There is nothing to imply that you would have any kind of special legal status, still less that you would have the same rights as if you were married. There is, however, then a significant debate in the early 1970s. So, for decades, the Social Security rules had tried to ensure that couples couldn't get any advantage by just living together as opposed to being married. So if in the context of means-tested benefits, your resources would be aggregated if you were married, then they'd also be aggregated if you were cohabiting. And this was known as the cohabitation rule. In the early 1970s, there are various campaigners saying that the rule is being applied too widely. It's being applied wherever a woman happens to have any kind of relationship with a man. You know, the mere presence of a man in her household is being seen as sufficient for his resources to be taken into account to cut her benefits. And so they say it shouldn't apply to all cases of cohabitation, it should only apply to those living in common law marriages, by which they mean stable, long-lasting relationships. They're just using it in a fairly colloquial way to denote that. But it's in the wake of that debate, and you can date this really precisely by looking at the questions that people are asking in problem pages and the letters they're writing into newspapers. In the wake of that, people begin to ask what rights they have as a result of their common law marriage. Now, in the early 1970s, the answer to that is, well, not very many. But from around 1974, the courts and Parliament start to extend rights to cohabitants. Only a few, and not very generously. But they do at least start. And it's the way in which those new rights are recorded and reported that's particularly misleading. So, in 1975, Parliament passes the Inheritance Provision for Family Independence Act. This, in itself, makes no mention of cohabitants or common law wives, common law husbands, anything of that kind. But it does allow somebody who is dependent on the deceased to apply to the court and claim provision from their estate. If they can show that the way in which the estate was divided didn't make reasonable provision for them. So it gives a right to apply to somebody who's dependent. This is the way that's reported in the Daily Express. This particular case involved a woman who had been dumped by her partner. If a bill now going through Parliament were law, she would, as a common law wife, automatically be entitled to a share in a husband's estate. The number of mistakes in that one sentence. Thinking, okay, first of all, the Act makes no mention of common law wife. Second, there's no automatic rights, it's a right to apply. Thirdly, it only applies if he's dead. So, as a jilted woman, she has absolutely no remedy as a result of this particular development. But this is just one example of many. The whole tenor of the debate from the mid-1970s takes these fairly minor new legal remedies, inflates them, and phrases them in terms of the rights of the common law wife. So, there's another example. This is a particularly famous case among law students. It's a property law case from 1975 in which Janet Eaves famously does lots of hard physical labour on the house that she's living with a cohabitant. And the judge is really impressed by this and is thinking that she wouldn't have been doing all of this work if she hadn't been expecting an interest in the property. She's reported as wielding a £14 sledgehammer. Now, some of you know I've been doing a lot of work renovating my house recently, and I was thinking, I must have been wielding a £14 sledgehammer. So I actually took the implement I've been using and I went and weighed it. And it was only £1. And that suddenly made me see this case in a totally different light. It's like, okay, I can see now why they were so impressed with the £14 sledgehammer, because that is heavy. But so it's a property law case, it's all decided under conventional, well, not entirely conventional application of property law, but property law rather than specific rights for cohabitants. And it's described in The Guardian, which is a respectable broadsheet newspaper, as security for common law wives. Daily Express also comes out with another classic headline. Cast off Janet wins share of house as ex-lover hits at charter for scheming women, which has no reference to common law wives in it, but does at least show how these developments were not universally welcomed. And it's not just in the print media that one finds this myth being propagated. There is a sitcom called Rings on Their Fingers, which is broadcast in 1978. And the whole plot of this is that the couple have been living together for 6 years. She wants to get married, he doesn't, he's dragging his feet. She threatens to leave him unless he puts a ring on her finger, and says, do you know, I'm entitled to 1/3 of your flat if we split up. She tells him that, she's got this from her friend's father, who's a judge, so he clearly knows what the law is. And the man clearly thinks, oh no, if we split up, I've got to give her 1/3 of the house, so I might as well just marry her. And they do. And this has over 10 million viewers. And you think, well, there is the common law marriage myth right there. You can tell we only had 3 channels in the 1970s because it is a truly terrible programme. I went to the British Film Institute to watch it because it's not been released on a box set for some inexplicable reason. And I sat through the whole series. Luckily, we only have 6 episodes in British sitcoms rather than the long mini-series. And then the lovely guy who was bringing me all these different reels of film said, where are you going? There's another series. And he sort of saw my face fall. It's all right, I'm only joking. But there was one final bit of research that I did to try to pin down exactly when the common law marriage myth emerged. So from all this, I was fairly satisfied that it had emerged during the 1970s. I'd seen references to couples actually believing in this myth by the early 1980s. So the final piece of research I did to test this was to look at women's magazines. I took a standard weekly magazine and looked at every single page of every single magazine for the entire 1970s. I got lots of recipes and knitting patterns, and in December 1979 I got absolute proof that by that point the common law marriage myth had emerged. So it is not something that we can trace back to the mid-18th century, but something we can trace back to misleading reporting and terrible TV shows in the 1970s. So, to conclude, English law never recognised common law marriage. While we can find examples of cohabitation in early periods, actually the scale of cohabitation in today's society is unprecedented. And the common law marriage myth only emerged in the 1970s, rather than having these deep historical roots that some have supposed. Thank you.
Thank you, Professor Probert. We now have time for questions, interaction. As we usually do, I'll just let Professor Probert kind of call on people unless there's a slew of hands that I can moderate. But yeah, if you have a question, please. Oh, so we already have a slew.
At the beginning, you'd mentioned 1753
Yes.
and the myth beginning there. Was there a singular event in that year?
Yes, so what happens in 1753 is that marriage is actually placed on a statutory footing for the first time. So before then, it's just governed by the church. In 1753, the legislation basically takes the church's requirements and imports them into statute, which is why that's seen as the dividing line. So common law is used to differentiate the non-statutory pre-1753 laws and the post-1753 statutes in that sense.
Well, I'm curious as to whether or not in current law a couple can make a declaration without involving the church, but still indicate, yes, we are married in our own minds and we should be entitled to the legal recognition that marriage provides.
So you can have a civil marriage.
Okay.
That's been possible in England and Wales since September 1837. And since the mid-90s, that's been the most popular way of getting married. And now I think about 75% of couples do that. But that does involve a process involving the state. We don't have a system where you can just self-declare that you're married.
Yeah, I don't want to put you too much on the spot here. I was just very interested about this solemnizing their vows, and that then you could be taken to court.
Yes.
Was there many cases then, in either in Old Bailey's or any others? Or how many people brought people to court, prosecuted for that?
Yeah, so it's not it would be in the church courts rather than in the criminal courts. The numbers, they're not big. We're talking about probably a handful each year in each court. So church courts are provincial courts. Each diocese would have its own court, and nobody actually has fully looked at the records of all of them as yet. But in the ones that have the most business, there's not very many by this point, because it's difficult. If one party is saying that this didn't happen, the other one is going to need witnesses to prove that it did. Mm-hmm. So you're immediately ruling out all of those cases where, the promise has been made under romantic circumstances where you don't have witnesses. And if one of the parties has married somebody else in the meantime, then, and has gone through a sort of a formal ceremony of marriage, then the church really prefers to uphold the formal ceremony as far as possible and make it even more difficult to prove this first informal exchange of vows.
What's happening in England this year with regard to common law marriages?
What's happening now in relation to common law marriages? Very little. So there's lots of exciting things that are happening in English family law at the moment. There are proposals to extend civil partnerships to opposite-sex couples. So at the moment, same-sex couples can either marry or have a civil partnership. Opposite sex couples can only get married. And there was a case that went all the way to the Supreme Court last year with a opposite sex couple saying that they wanted a civil partnership. So that's going through, and that will provide an option for those couples who have ideological objections to marriage to formalise their relationship. I don't quite get why you would be happy to have a civil partnership but not a marriage, because the rights are exactly the same. So I think if you're claiming that one is patriarchal and the other isn't, it is just about the label rather than the substance. But there's no proposals at the moment to give any more rights to cohabiting couples, despite a lot of people arguing that they should have more rights. Go on, Melanie.
Yes, I'm back to the records and stuff, and I'm interested in knowing who would be the informant in cases of fornication.
So, parish officials might have a duty to report couples to the church courts. Every few years, the bishop would effectively send out a questionnaire asking about a variety of different things. You know, are people going to church? Do you have any married couples who are living apart? Do you have any couples living together who shouldn't be? And parish officials were expected to make a return. And in the meantime, if they were aware of these events occurring, they were expected to report them to the church courts for appropriate action to be taken. You may have noticed in the chart that I put up that the number of women being punished for fornication was higher than the number of men, which is because it was generally more obvious whether or not women had been engaging in sex outside marriage when they became pregnant. But it's clear that men were punished as well. It wasn't just the women who were pursued for this. But it's always impossible to think ourselves back to the early 18th century and the extent of social control that was exercised. But you had so little privacy in this period. You had neighbours who would be keeping a watch on your activities. And they had a very powerful economic reason for doing so. Because if you had a child outside marriage and you fell on hard times and you needed support from the parish, that child was settled in that parish. And that child might be a drain on the parish for the rest of its life. The neighbours would be supporting it. If the parents were married, then the child was settled wherever the husband was settled. So, you know, people might come into the parish from elsewhere and you check that they're married, because you don't want to find out at a later date that this particular pair weren't married and that the string of children that they've produced while living in the parish are all going to be paid for essentially from your pocket. So people check. People keep an eye on each other.
You made a brief mention of immigration, and I'm curious in the current tradition and when it started to begin, that people coming in from different marriage traditions are factored into the British law or the canon or
Yeah.
religious.
So that's a really good question, and the basic answer is 1856, because as I mentioned, civil marriages made a possibility in 1836. The law comes into force in September 1837. That allows not only for civil marriage but also for the rights of marriage according to any other religion. At that point it says Christian religion, but in 1856 when they amend the law, they take out Christian. And English law didn't work on the basis of listing religions. Basically, if you had a place of worship and you registered it for marriage, if you had 20 people who could say that this was their usual place of worship, you could register it for marriage and you could have weddings there. So it proved possible to encompass Muslims and Hindus and Sikhs within that framework. Now it's been realised relatively recently that that framework doesn't necessarily work very well for them because they don't necessarily want to get married in that particular place of worship. They have different traditions. But the law has at least recognised them to the sense of saying you have the option of doing this. You have the option of registering your mosque and having a legally binding marriage within that mosque. We might need to change it for the future though.
Any questions, comments?
And one more.
Okay.
But it's
Melanie has students here, so she's making sure she asks all the questions they need to hear for their papers and tests.
exactly. But now it's more out of interest. You were talking in 1974 about the inheritance and the provision for the family dependent, and then you did mention how the myth and how the rights of the common law wife. At that time, do we talk about the right of the common law husband?
Very rarely, yeah.
So,
So the term does appear, but much less. And in terms of portraying rights, it's always protection for the common law wife. It's never protection for the common law husband.
the common law husband has no rights then,
Oh,
in the imaginary of people, or what do they have as a right anyways? Right to what?
But it would have been the common law husband who probably had the job, the home, the income, and
Yeah.
so on, so he didn't need those rights.
Yeah, you have far fewer men in a position where they need to claim them.
Especially in the 1970s.
Yes, yeah, absolutely.
Thank you.
Well, thank you again. We'll get started again. Again, this is Dr. Katharine Batlan, who is the Ronning Center's postdoctoral fellow, and she's going to be speaking to us about recent and contemporary religious responses to marriage law changes in the American context.
Thank you. Thank you to Melanie and to the Chester Ronning Center, and also to Professor Probert for letting us be a part of this wonderful event today. So today I'm going to be talking about some of the legal parameters and religious responses to marriage law changes in the U.S. I'll discuss this most recent change, allowing for same-sex marriage, but in order to do so, because I'm trained as a historian, I'm going to take you back in history to discuss more of the relationship between marriage law and religious communities in the U.S. context. I assert that marriage is typically left to states in the U.S., so the U.S. federal government only gets involved in marriage law when the conversations reach a highly agitated state, and have only really done sort of deep changes to marriage law for the whole nation in 3 instances. Bigamy, interracial marriage, and same-sex marriage. Each time, religious Americans were involved in those conversations and agitation. With each change, we see some of those religious responses, which include people using religiously informed arguments either to support or challenge U.S. federal stances. So in order to begin, I'm going to take you back to the American founding, which is cliche, but I do so because it helps set up the American constitutional system in which those religious disputes over marriage laws arose. To start, the U.S. Constitution, nor the Bill of Rights, which are the first 10 amendments to the Constitution, includes any mention of marriage. Though the U.S. Congress is given power in Article 1 to pass laws that are, quote, necessary and proper, The Bill of Rights' 10th Amendment, ratified only 3 years after the Constitution, includes, quote, "the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people," end quote. This included anything not listed as a power of the federal government or something states weren't allowed to do. States, for example, couldn't enter into treaties with foreign governments. The US Bill of Rights isn't nearly as exhaustive as the Canadian Charter of Rights and Freedoms, but actually neither addresses marriage rights. So in both places, marriage legislation and ruling had to be done through different mechanisms than by assumed protected freedoms. Also, because the US powers are not enumerated or listed as federal government powers, states were in charge of any marriage laws they deemed necessary. So states had variations on different things like age requirements, who could officiate, whether it's only religious clergy or also including civil magistrates, kind of in line with what you were talking about, with the New York court deciding that could be outside of religious contexts, and how a couple went through official licensing and processing fees. Overall, though, legislation in various states overlapped greatly on many of the main parameters of what was allowable. The first major challenge to marriage law in the US on a grand scale was bigamy. This became an issue when Joseph Smith, the founder and prophet leading the Church of Jesus Christ of Latter-day Saints, had a revelation that righteous followers should engage in marriages between one man and multiple women, in a practice Smith invoked as hearkening back to what Hebrew Bible or Old Testament prophets and patriarchs engaged in. Latter-day Saints claimed not only that Hebrew Bible patriarchs engaged in marriages between one man and multiple women, but also that Smith had a particular revelation in which to restart this practice again, as important for Latter-day Saints to reach the highest levels of heaven. You can see a picture of a Revelation book in which some of his revelations are recorded here. This new religion, founded in 1830, challenged the status quo of Christianity in America on a variety of fronts. But the bigamous practice that developed became a focal point for mainstream Protestants who were culturally and politically dominant in the US. In fact, the newly formed Republican Party included in its first ever political platform in 1856 as working on to fight, quote, "the twin relics of barbarism," by which they meant the issue of bigamy as an equally pressing problem to slavery. Here you see a political cartoon about it, in which you have, the Cincinnati platform seen as polygamy and slavery, upon which he's trying to get all the balls rolling for the Republican Party. Latter-day Saints had moved from states that were hostile to them. So hostile, in fact, that their first leader, Joseph Smith, was assassinated. The governor of Missouri called for all Latter-day Saints to be exterminated in his state. And there were hundreds of political cartoons, books, and articles outlining what Protestant, sort of mainstream Protestant Americans imagined about Mormon bigamy here. So we have the Elder's Happy Home with tons of women in a bed. Here we have women chained up as if they are enslaved in some way. And then a very famous tell-all of a woman. As a result, most Latter-day Saints made their way across the continent to the Utah Territory following the leadership of Brigham Young. There, bigamous Latter-day Saints were away from states in which there were already anti-bigamy laws on the books. But the mainstream Protestant fear about this continued. This is when the federal government started to get involved in some of these marriage questions. Beginning in 1862 with the Morrill Anti-Bigamy Act, the federal government, for the first time really, headed into marriage laws. As a federal territory, Utah was under federal control, so that's part of why they get involved at this time. Latter-day Saints attempted to fight back in court, claiming that they had a religious freedom protection that's in the First Amendment of the US Constitution, free exercise of religion. But the federal courts upheld these laws. In fact, because Latter-day Saints continue to practice this form of marriage, the federal government passed increasingly restrictive laws throughout the end of the 19th century to punish bigamy. Eventually, in 1890, the Latter-day Saint president and prophet at the time, Wilford Woodruff, announced that Latter-day Saints would stop practicing bigamy. This did not end all fears, and some Latter-day Saints split off from the main Church of Jesus Christ of Latter-day Saints because of this change. But this official change of the larger group of the church led the federal government to mostly subside its interest in anti-bigamy legislation. Around the turn of the 20th century, some Protestants were involved in projects like prohibition of alcohol. They also, these same groups, often tried to get the federal government to enact uniform marriage and divorce laws across all states. They did not succeed. This is not one that's particularly well known, and I only because of my work on constitutional amendments that I found out about this. They did get a few congressmen to introduce bills to change the US Constitution, making for uniform marriage and divorce laws. But seeing as there have been over 11,000 proposed amendments to the US Constitution, it was not a very likely outcome. It's much harder to explain why something did occur, but instead of why something occurred. But my take on this is that it's very hard to amend a constitution. This is highly unlikely, and there was no real pressing threat. This was just part of these Protestant reformers' excitement to try to change things in the US, whereas prohibition of alcohol had a lot more steam behind it, but that's a different issue, not about marriage. Instead, the US government predominantly stayed out of disputes over who could or could not marry until 1967. That was when the US Supreme Court overturned state anti-miscegenation laws that prohibited people of different races to marry. In 1967, when the case Loving versus Virginia was decided, 16 states had anti-miscegenation laws on the books. One of the issues at play in this case was because there were different laws in different states that were coming to a head at a time of increased interest and fervor over civil rights for racial minorities. The Lovings had married in Washington, D.C., but lived in Virginia, which had anti-miscegenation laws. The couple's home, speaking of how do you find out about this, was raided in the early morning in an attempt to catch them together in bed. The couple was Mrs. Loving famously pointed to their marriage certificate on the wall and said, "We are married," and the people raiding their home said, "That's not valid here." They then went to court over this. The lower court ruled against the couple, with the county judge claiming, and these are his words, not mine, I understand it might be offensive, Almighty God created the races, white, black, yellow, Malay, and red, and he placed them on separate continents. For the interference with his arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix. End quote. This is a perspective promoted by white conservative Protestants in the US for many, many years. The US Supreme Court eventually overturned this lower court ruling, stating that the 14th Amendment section, which prohibits states from denying any person equal protection of the laws and doesn't allow states to, quote, deprive any person of life, liberty, or property without due process of law. These clauses in the 14th Amendment allow the Supreme Court to state that the Lovings were denied their equal protection that other Virginians received, as well as being denied their due process. Though some religious organizations supported this decision, others continued to promote the ideals that lower court judge promoted about racialized, separated order created by God. One of those religious institutions that continued to promote anti-miscegenation was Bob Jones University. Oh, sorry. Bob Jones. Bob Jones University was founded in 1927 by Bob Jones Sr., a fundamentalist Protestant Christian. And this school did not admit any black students until 1971. Even after that, they would not admit students who were engaged in interracial marriage or dating. And the disciplinary rule book of students enrolled at school there prohibited them from dating interracially as well. In 1970, the Internal Revenue Service, or kind of like Canada Revenue, yeah, Revenue Canada. Anyways, okay. As a reaction to, and in order to comply with the civil rights laws passed by the US Congress in the 1960s, announced they would no longer allow private schools, which had racially discriminatory admissions practices, to be tax exempt. So Bob Jones University was under scrutiny. In their case, the US Supreme Court ruled against the university, despite the fact that Bob Jones University claimed that the Bible forbid interracial dating and marriage, using the same sort of reasoning that that lower court judge had used in the Levin case. Instead, a unanimous Supreme Court claimed that the IRS was bound by law to only view, quote, charitable trusts, educational or otherwise, as subject to the requirement that the purpose of the trust not be illegal or contrary to public policy. The court determined that because public policy in the 1950s and 60s increasingly rejected racial discrimination, Bob Jones' admissions policy went against these non-discriminatory public policy aims of the federal government. Even though the university claimed a religious reason for their policy, the court decided the state had a compelling interest in prohibiting racial discrimination. Again, the federal government only moved on this marriage issue when it became a highly contentious question. Finally, this brings me to recent events. Controversy over same-sex marriage. The US Supreme Court ruled in 2015 in the case Obergefell versus Hodges that the equal protection and due process clauses of the 14th Amendment protected couples of the same sex to marry as well, using that same sort of reasoning from Loving. This was again a moment in which we saw public interest in different states and different states having different policies raising this question to the federal level. Some states had legalized same-sex marriage, some had not. Some lower courts had decided in favor of the rights of same-sex couples' petitions to marry, others had not. There were also several different cases from different places in the US that made its way up to the Supreme Court, and there was no real sort of clear answer for judges to decide. A divided Supreme Court, so unlike in Loving and in the Bob Jones case, it was a 5-4 decision instead of a 9-0, decided in favor of same-sex marriage and used those same arguments from Loving to do so, equal protection and due process. The case included petitions of 14 couples and 2 men whose partners had deceased, raising again sort of the question of what do people who cohabitate, what kind of rights do they have after someone dies? Again, some like Loving wanted the state in which they resided to fully recognize a marriage that they had in a different state, whereas others asked that they be allowed to marry in the state in which they reside with a same-sex marriage ban on the books at the time. Though some conservative religious people claimed same-sex marriage was against religious law and undermined the family structure set out by God, which I'll discuss a little more in a bit, the petitioners overwhelmingly claimed that they saw a great value in marriage. They wanted both the privileges and the responsibilities that came along with the marriage label. Some of the amicus curiae, or Friends of the Court briefs, submitted alongside the case outlined specifically religious support for same-sex marriage. A Quaker community argued that because they believe God is present in all people, all are equal, and so to deny same-sex couples the ability to marry is to deny that part of God that's in them and their equality, fundamental equality. A group of Episcopal, it was a big sort of list of people who signed on to this one. Episcopal, United Church of Christ, Reconstructionist Jews, Reform Jews, Unitarian Universalists, Progressive Muslims, Methodists, and some others, joined together to assert their support of same-sex marriage. In their brief, they argued that conservative religious voices were dominating these arguments against same-sex marriage, but insisted that there was no single religious stance on same-sex marriage. They claimed to support same-sex couples to religiously marry in their communities and wanted those couples to have the same legal protections. The Presbyterian Church of the USA, for example, changed their Book of Order to state marriage is, quote, a unique commitment between two people. And as you likely heard, the case was decided in favor of the right of same-sex couples to marry, but it didn't stop being an issue. Just as we saw with interracial marriage. Instead, some of those who have disagreed with the decision have brought suit or refused to issue marriage licenses. Their questions, like the Bob Jones University case, involve a religious component. For example, immediately following the Supreme Court decision, the governor of Kentucky issued an order that all county clerks should comply with the decision, stating, quote, neither your oath nor the Supreme Court dictates what you must believe, but as elected officials, they do prescribe how you must act, end quote. Kim Davis, a county clerk from Kentucky, did not agree with the governor that her oath of office compelled her to obey the Supreme Court ruling. Instead, she decided to refuse to issue marriage licenses to anyone. A move, she claimed, was to try to avoid being charged with particular discrimination. She just wouldn't give them to anybody. For Davis, she claimed God's authority described homosexuality as an abomination, and so she was unable to issue marriage licenses. Many same-sex couples came to her office, and she refused to issue them marriage licenses. And 6 of those couples ended up suing her. She has written a small book outlining her fight, in which she describes herself as a willing vessel for God. She asks, quote, how can the court pass judgment on God's plan for marriage, end quote. She also reveals in her book that she has several gay friends who came and talked with her and supported her, respected her decision throughout the trials. She asserts that she did not refuse these requests for marriage licenses because she was bigoted, but instead because it is a religious conviction. She can still be a good friend to all. At the heart of her legal plea was that as a county clerk, she had to sign marriage licenses. And she claimed that doing so would be signing off on marriages that she could not religiously consent to. She couldn't in good conscience do. The lawyers for the opposition stated that this was a part of her job as a county clerk, and rather than signing as an endorsement of the union, the county clerk's signature is simply there to verify that the information on the license was accurate. The judge sided with the same-sex couples and ordered Davis to issue marriage licenses to everyone. She again refused and appealed to a higher court, but the circuit court refused to take her case. They didn't see that she had any sort of legitimate claim. She appealed again to the US Supreme Court, who also refused to hear her case. So, because she had continued to refuse to issue marriage licenses and had been denied these appeals, she had disobeyed a lower court's ruling to issue marriage licenses and was found in contempt of court and sent to jail. After 6 days, she was released, and instead of her issuing the marriage licenses, her clerks issued marriage licenses on her behalf. She was still not very happy with this decision, this sort of accommodation given to her, until in 2016, a year later, the Kentucky legislature passed a law that removed the signature of county clerks entirely from marriage licenses. Instead, they're only on marriage license applications, and only the officiant signs the license as sort of the arbiter of the state. Despite getting back to work, though, last fall, Davis lost her re-election campaign to one of the gay men she turned away. Finally, another high-profile case that the U.S. Supreme Court did actually hear was Masterpiece Cake Shop versus the Colorado Civil Rights Commission. This case is a little bit different. In this case, a bakery owner refused to make a cake for a same-sex wedding, citing his religious convictions. The Colorado Civil Rights Commission found that the baker was in violation of state anti-discrimination law. Unlike in Kim Davis's case, where the Supreme Court did not take up the case, in the cake shop one, it did. In a 6-2 decision, the court sided with the baker's religious liberty claim, stating that the Colorado Human Rights Commission showed contempt towards the baker's religious beliefs. Though the majority of the court conceded that a person providing a service to the public might be restricted by generally applicable laws, the Human Rights Commission, the court deemed, did not treat the baker's concerns in a religiously neutral way in deciding whether or not he could refuse the job. So the baker, even though the baker won this particular case, his story is actually not over because he recently over the summer, refused a transgender customer who requested a gender reveal cake and is now fighting with the Colorado Human Rights Commission again. So, that one continues. These are some of the ways in which law, marriage, and religion have come together, sometimes clashing in U.S. history. As you can see, in the U.S. system, states are predominantly left to legislate marriage content. But in these sort of highly contentious cases, dealing with bigamy, interracial marriage, and same-sex marriage, the federal government does sometimes get involved. It's unlikely that same-sex marriage disputes will go away anytime soon. I know that there have been several high-profile cases in Canada as well. And there are cases working their way through the US courts even now. It'll be interesting to see if they follow sort of the cycle of dropping out of public light once the issue becomes less highly agitated, or if we're in some sort of new phase. There are some differences. As opposed to during interracial marriage questions, we have a much more divided Supreme Court being a sort of important new factor. What might be next on the radar of the federal government in relation to marriage, I do not know because I'm a historian. But I'm sure religious people will have opinions. Thanks.
So questions, follow-up comments for Dr. Batlan?
Yes?
The interesting thing about the Colorado cake maker, Katharine, is that his lawyers are trying to pit the First Amendment, are trying to use the First Amendment in favor of the cake of his side. In that he says he mass produces all kinds of cakes and is perfectly willing to sell a cake to anybody, transgender, gay, whatever. What he's not willing to do is artistically produce a special cake for a transgender person, a gay couple, whatever, and that to require him to do so would be a violation of his freedom of speech in the context of artistic freedom. But anybody is welcome to buy one of his generic ways.
Right. Yeah, and that was one of the most interesting parts I thought of that decision was when the Supreme Court took up the question of artistic license and whether he had the ability to refuse as an artist rather than as a person who provides a public good.
The first time I knew making cakes was an art form.
Well, if you go to his website, you can see a lot of pictures of him toiling over his masterpieces. Yeah?
I'm going to, it's not your research, but have you seen the law on bigamy? I mean, especially because there's not one federal law, so it has to be all those state laws. Isn't there any that you read? I haven't gone to read the stuff, but have you read any of those laws of bigamy?
Yes.
Yeah, okay, and what do they say then? What is it? The
Bigamy?
definition, yeah.
It's typically one man with multiple wives, because a lot of them were written in the 19th century. And so that's sort of the language that they use.
So would it be if you in Canada there's a distinction. I mean, because of the Mormons who came, and our criminal code came in 1892. So we have two sections. We have a section of bigamy, and bigamy is to marry, to go through the formality of marriage.
Mm-hmm.
Polygamy is to live conjugally with many people.
Yeah.
Is there a statute somehow, a criminal law, against the fact of going through a marriage ceremony?
So I am not sure exactly the parameters, but I do know Utah has, the state of Utah has some more restrictive laws that go again, that try to get at those questions of, but also I know that because cohabitation has been decriminalized in most states, it's not really possible to prosecute people for bigamy as long as they're not trying to get another marriage license from the state. If they go through some sort of religious ceremony, in most states, that's not prosecutable. But I'm pretty sure Utah has tried to close some of those loopholes. I don't know if they've been fully successful at that.
Did you check that, Rebecca, yourself? In the States, did you check their laws?
I haven't looked at the state.
No, me neither. We don't like the States. I'm just teasing.
You have used the term religious repeatedly. Would it be more accurate to say evangelical?
So I think probably in the context of this particular talk, a lot of what I'm talking about are sort of Protestant Christian ideas. Evangelical is a hard word to define. People in my field, it's a contested category, and even among people who self-identify as evangelical, it's an amorphous category. So that could be difficult. I don't know. I tend to use religious just because sometimes I use examples from different religious communities, but in the US, Protestant Christians have dominated a lot of the conversations. So that might be a more accurate way to put it.
So you mentioned that there was a lot of fear among mainstream Protestantism against more bigamy. Why was there so much fear, and what was the source of that? Was it religious, or was it just fear of the unknown?
So there are a few factors that are probably at play there. This isn't my primary area of research, but I do know the Mormon tradition grew fairly rapidly. So part of the threat is that there are lots of people converting, there are lots of people following, they're moving across the continent altogether. So there's this sort of excitement there, just with numbers. It's also when the Latter-day Saint tradition was founded, was also a time of intense religious fervor. There were a lot of revivals happening at the same time, and also other new religious movements that emerged in that time period. So there just were a lot of sort of moving pieces with religious communities in the 1830s in particular that got people excited. The other thing, though, I think is that, just my sort of take on it is that bigamy is interesting. All of those pictures of these sort of salacious and the salacious accounts of things, it played into sort of the imagination of people who are very concerned about moral order and authority. Just my take. Yeah.
So I thought it was very interesting, the three occasions where the federal states enact marriage legislation. The first one is sort of prohibiting, and the second two are facilitating. Is there any push to recognise polygamous unions now?
Not that I know of. That's a great question, though. And I think it's an interesting one, given that Mormons aren't the only people who practice forms of bigamy. People do it non-religiously as well. So it could be interesting, but I haven't really seen any pushes in the U.S. personally.
If
but-
I may, Rebecca, when we were discussing opening the definition of marriage for same-sex here, there were briefs coming out about let's legalize polygamy as well.
Yeah.
Not bigamy, but polygamy. And there was briefs saying if we legalize same-sex couples, we will have polygamy.
Oh, yes,
So there was this
yes,
fear
yeah,
as well that it was going to open.
That
So-
definitely happened in the US as well, of a fear of what this will open up for
But,
everyone.
Yeah,
but there's a
held
real
up as that.
movement to
Yeah.
legalize it too, right now.
Can I